My name is Rosie McCool with the Chief Probation Officers of California. We are very excited today to be here with Mark Perkinson from JBI, Justice Benefits, to discuss Title IV-E and to take questions. So known Mark for quite some time now and has been a great partner and resource. So happy to have you here with us this afternoon to spend a little bit of time talking us through Title IV-E at a very high level, and then certainly taking any and all questions that folks may have. So with that, I'm going to go over a few housekeeping items, and then I will turn it over to Mark. First, if you could just keep yourselves on mute if you are not asking a question. And then certainly as we go, if you do have questions, feel free to either drop those in the chat. Myself and Katie Flores will be monitoring that. And then you can certainly use the raise your hand function if you have questions that you would like to ask. So two different ways, depending on what your comfort level is. We will also, following the informational workshop, be sending out a copy of the PowerPoint material so that you will have that information as well. So be on the lookout for that. And I think with that, that concludes all of our general announcements. And with that, I will just turn it over to you, Mark. Very excited for your time this afternoon and very much encourage folks to ask questions as you have them, and we'll work our way through those. So with that, Mark, I will turn it over to you.
Thanks, Rosie, and really appreciate the opportunity to bring this to you today. And I'm going to be honest, I kind of struggled with this presentation a little bit just because I knew that we would have JBI clients. We knew that we would have non-JBI clients. And as I was working through the presentation and reviewing with my boss, he's like, no, you got to take that out. You have to take this out. You have to take that out. So in the end, what we ended up with, like Rosie said, it is a very high level look at Title IV-E. It's really going to give you the basics that you need to claim successfully without really getting into the weeds. But I do have a formal presentation, but I really want to look at this as more of an informal time for you to ask me questions about anything we might be going over in any of the slides. So feel free to stop me whenever you want. Whenever you have a question, I'll answer it to the best of my ability. And if I don't know the answer, I'll tell you and I'll look it up for you. But it's great to see so many familiar names today. And for those that I'm not familiar with, well, I look forward to meeting and chatting with you. So with that being said, I'm going to go ahead and share my screen and we'll jump into it.
All right. And while you're doing that, Mark, and getting that set up, I neglected to mention that JBI is a probation partner of CPOC. So thank you for that, Mark. And then certainly, I know one of the things Mark will also be spending some time on is just the work that JBI does and the help that they can provide related to claiming and so forth with their time studies and that service. So that will also, I think, be a function of today's workshop as well. So I see we are all ready to go, so I'll turn it back over to you.
Yeah, good to go. Thanks. Yeah, so I guess I'll introduce myself first. Rosie did a great job already, but I'll tell you a little bit more. I'm Mark Perkinson. I'm the Senior Vice President of Title IV Operations at JBI. So I oversee our time study, I oversee our candidate compliance program, I oversee our training curriculums. So if you've ever had anyone come on site to your county to do a training, to do a compliance review, if you're answering the time study, well, the buck stops with me on all that stuff. So, I've been with JBI now for 21 years. It's kind of crazy to think that, but wow, what a ride it's been. But yeah, we'll go ahead and jump into this. And first of all, I want you to know what Title IV-E is. And Title IV-E is actually, at its heart, it's really our federal foster care and removal prevention program. And it is governed by the Social Security Act, which has been around since 1935. And it's had several changes, of course, since then. But one of the most notable changes occurred in 1980 when Congress wanted to address what was known as the foster care drift. And basically what the foster care drift was youth going into placement and just aging out of the system, and not really having a chance to be reunited with their families, or if parental rights had to be terminated to be adopted out into forever families, forever homes that way. So in 1980, a lot of the placement side changes that we adhere to today came into being. So just a few examples are our monthly face-to-face visits with our youth that are in placement, our 6-month administrative hearings, and our annual permanency hearings. So all these things came into place to try and reunite families that have been separated by a foster care placement. And also in the 1980s, there began to be a little bit of a shift to where if we could provide services up front, perhaps that could lead to fewer foster care placements to begin with. So candidacy actually came into being in 1987 through a Department of Appeals board hearing, and it's been around ever since. So there's a couple sides to Title 4E. Uh, the first side is going to be maintenance, or in California, it's called assistance. But that's kind of those are going to be the costs of care for eligible youth that are placed in foster care. So that's going to be your like your room and board, your clothing, things like that for eligible youth in foster care. What JBI really specializes in, though, is the administrative side. And anytime I talk about administrative and administration, those are typically going to be your costs that are derived from a time study or case management. So really, anytime you as probation officers are doing case management for youth that are in foster care, for youth that are reasonable candidates, for your non-minor dependents, you're actually administering the Social Security Act. And that's the time that we're actually trying to capture through the time study. So to understand Title 4E, we need to understand where those federal guidelines are coming from. The federal guidelines are going to be outlined, like I said, first and foremost in the Social Security Act in sections 471 to 479. And you're also going to find some regulations in the Code of Federal Regulations. The 45th series in 1356 is going to have a lot of information about Title 4E. We're going to look at some of that information today. And also the Child Welfare Policy Manual is going to provide information on Title 4E on both the program side and the fiscal side. And the second series of CFRs in 200 and 225, that's going to be your basically your fiscal regulations for putting together your claims on the financial side. So basically, when you look at the federal guidelines, those are going to be your minimum guidelines that you have to follow. Now, states can come in and they have the option to provide or to implement even more guidelines. So in California, the state guidelines that we need to adhere to are first and foremost the California County Cost Allocation Plan. And this is an annual plan that CDSS submits to the federal government, the Administration of Children and Families, the Children's Bureau. And it's basically the state saying this is how we're going to claim Title 4E for this fiscal year. And they'll go back and forth with questions and answers, and often it's a pretty lengthy process. But ultimately, what's in that county cost allocation plan is how we need to basically administer the program. But we also, on top of that, we have county fiscal letters and all county letters that are going to provide us even more information on how we claim. And the guiding CFL and ACL for probation claiming are really going to be CFL 14, 15, 29, And that is basically how we put together fiscal claims for probation in California, and ACL 1436, which is how we claim candidates in California. And I did want to, like I mentioned before, today's going to be very high level. If you want a deep dive into candidacy, Greg Lazard and myself recently recorded a very deep dive into candidacy. So, and that will be coming soon to on-demand training on the CPOC training site. So keep an eye out for that if you want a deep dive into ACL 1436, into the federal audit that led to ACL 1436, how to actually work through your evaluation of imminent risk and reasonable candidacy, how to work through your case plans, and how to claim candidates, and then what you how you should prepare for a CDSS candidate review. So like I said, it's pretty detailed, and that will be coming soon. And JBI is also happy to provide training to any JBI client that would want that or need that. So why time study? My administrative assistant is very kind to me. That's probably what I looked at like when I started at JBI, but now I've got the receding hairline, the bald spot, and my beard is more gray than black. But that's what time does, right? Okay, so why time study? In order to claim administrative costs, counties must develop a method to measure the amount of time spent doing activities to claim those Title 40 federal funds. And in California, we are able to time study by 3 methods. We can use a continuous time study where we track basically all of our hours in the day to the closest 15 minutes to determine our time study percentages. There's also a mid-month time study where you only time study in the mid-month, which would be November, February, May, August, and it's kind of the same concept as a continuous time study. And then we also have a random moment time study as well, so which is also continuous. So those are the 3 methodologies in California that are allowed for time study, and JBI actually has products for all 3 of those. But in coding our time in the time study, we have to understand what is allowable and what is not allowable for Title 40 purposes. This is going to be one of the most basic things that we have to understand in order to successfully capture our time. So allowable administrative activities are defined in 45 CFR 1356.6 in C2, if you want to get specific. And those are going to be training, referrals to services, preparation for and participation in judicial determinations, placement of the child, updating a case plan, case reviews, case management and supervision, data collection, and reporting. Now, in California, we don't have codes for all these things. Everything but training is lumped into one category called case management. So in our time studies, you're going to see case management codes. So what do we mean by case management and court-related activities? So these are going to be your activities that include but are not limited to any collateral or face-to-face contacts with the child, the family, or any persons that are familiar with the child's case. That could be teachers, counselors, case managers, etc. Also assessing the child and family's need for services, developing the child's case plans and case plan reviews, referring the child and family to services and treatments, placement referrals, which would also include anything that you need to get together for your eligibility packets for your child welfare department to do a determination for that child for their placement, and entering chronos, case notes, filing, and then any travel, paperwork, email, phone calls, and data entry that's associated with case management can be case management activities as well. All right, so those are wow, those two words don't go very well together. Anyway, those were our allowable activities. So we also have to understand what is unallowable when we're looking at Title 4E. And our unallowable activities are also going to be found in 45 CFR 1356.6. And the first is arranging for services. So what's the difference between arranging for services and referring to services? So if you're arranging for services, you're actually you're actually setting those services up for the family, as opposed to the referral where you give the families the information to set up their appointment and do that. Um, so that's kind of the main difference. Also, what we cannot claim in Title 4E, traditional Title 4E, are any direct services and counseling. That's largely because those type of activities are covered under Title 4B, as in Title 4B, and that's basically a block grant that goes to CDSS, and CDSS passes that down to the child welfare departments. And the child welfare departments probably aren't going to share that with you. And in addition to those things, any activities that we perform on behalf of youth in custody, so any youth that are locked in a secure facility like a juvenile hall, detention, basically a camp, basically anytime there's a lock on the door, we cannot claim that. And then we also cannot claim law enforcement related activities either. And that's largely because Title 4E is a child welfare program. It's not a correctional program. So what do I mean by law enforcement activities and probation specific activities? So regardless of who you are doing these activities for, even if it's a reasonable candidate or a youth in foster care or a non-minor dependent, we can't end up claiming these activities. These are going to be directives to apprehend. So any activity regarding a warrant, whether you're obtaining or executing a warrant, if you're in the process of arresting the child, the minor, the youth, if you're applying restraints, anything related to that type of activity, we cannot claim. You would have to code that type of activity to probation only. In fact, we have to code all these types of activities to probation only. So this also includes conducting searches for contraband, any activity that's directly related to a GPS or electronic monitor device, activities that are directly related to drug tests, polygraphs, curfew checks, collecting fees, victim services, really just anything having to do with restitution, and then supervising community service. Those are all going to be unallowable activities. And then also travel, paperwork, email, phone calls, and data entry that's associated with these probation specific activities would also be probation specific. All right, so any questions over allowable and unallowable activities?
Yeah, and I would just remind folks, you can either raise your hand and we can and unmute yourself and we'll call on you, or you can use the chat function to ask any questions.
All right. Well, now that we know it's claimable, let's look at who we can claim for. So our claimable populations in Title 4E are going to be minors in foster care. It's going to be our AB 12 non-minor dependents and extended foster care, and our minors that are at serious risk of entering foster care absent preventative services, also known as reasonable candidates. So here is basically a simple equation that will tell you whether or not you have reimbursable time. So if you're working with a claimable population, a reasonable candidate, a foster youth, or a non-minor dependent, and you're doing an allowable activity, that equals reimbursable time. So if you change any part of this equation, so if you're working, say, with a non-candidate, at that point, you're you have non-reimbursable time because they are not a federally eligible or federally claimable population. So if you're working with a claimable population, but you're doing an unallowable activity, that would also lead to unreimbursable time. So but both of these have to be true in order for us to have reimbursable time. You have to have a claimable population and you have to have an allowable activity. Now, I'm gonna go back real quick to this slide. Just because our our minors in foster care, our non-minor dependents in extended foster care, those are pretty easy to identify. You've got placement orders for those youth. You have eligibility packets. You've got stuff like that. So they're relatively easy to identify. The ones that are not relatively easy to identify are reasonable candidates. And reasonable candidates are important because the only way that we can actually claim for a youth that is in the community with their parents or legal guardians is if they are reasonable candidates. So let's take a look at just a high level look at candidacy and case plan basics. Sorry, I've been kind of fighting the cough and cold the last couple days. It's clearing up now, but my mouth gets really dry. Anyway,
Nope.
so let's first take a look at a federal definition of a candidate. When I look at the federal definition of a candidate, I kind of see it as three prongs, right? And for a youth to be a candidate, all three prongs have to be true. So the first prong is that a candidate for foster care is a child who is at imminent or serious risk of removal from the home. The second thing that we need to look for is that the state agency and your probation department is actually an extension of CVSS by way of your MOU with your child welfare department. So your probation department is either pursuing that youth removal from the home or you're making reasonable efforts to prevent that removal. And typically in a probation setting, what those reasonable efforts are going to look like are the services that you're providing to the youth and the parents to help keep that family together. And absent these services, or should preventative services fail, the minor could be removed from the home into foster care. And by this, what I mean is if there is a 0% chance that this youth would ever go to foster care, they would go to a detention setting, they would go to camp, they would go to some other secure facility, then you're not dealing with a candidate. But if there is a chance that this minor would go to foster care if the services fail, then you could potentially be working with a candidate if we're able to document that accordingly. So we need all three of these things. We need the youth to be at imminent or serious risk of removal from the home. You're providing services to prevent that removal. And if the services were to fail, or if the youth were not receiving those services, then the likely placement for that youth would be foster care. So you have to take a look at what we see in order to determine candidacy. In the Child Welfare Policy Manual, it stated that just because a child is involved with your agency doesn't automatically make that child a candidate. And we know that youth come to probation because they've done some sort of delinquent behavior. But we cannot determine candidacy solely based on a minor's delinquent behavior. We have to look at the welfare and safety of the family as well. We have to take a holistic look at the family and ask ourselves, what 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 are the family dynamics? What are the safety issues in the home? What are the actions and inactions of the parent that could potentially lead to a foster care placement? And we have to look at, if there are no welfare and safety issues, then we can't justify that youth as a candidate just based on delinquent behavior. So I want to give you a few things that you can look at when you're trying to determine candidacy. Some potential things that you can, and this is not an all-inclusive list, but these are just a few things that you can kind of look at with the parents, with the family, to help you along with your candidacy determinations. So if the parents are legal guardians, if they have a hostile attitude towards the youth, if they're kicking the youth out of the home on a regular basis, if there's a lack of adequate housing, physical or mental or verbal abuse towards the youth or any other family members for that matter, if there's a lack of parenting skills, substance abuse, mental health problems that hinder supervision, if the parents are failing to report runaways, if they're allowing the youth to not attend school, if they're minimizing that youth's behavior or failing to report violations, you may be working with a family that would qualify for candidacy. And I do want to address substance abuse, but I'm going to address that when we take a look at the evaluation of eminent risk and reasonable candidacy. And the evaluation, and that's what we're going to talk about next, the evaluation of eminent risk and reasonable candidacy, which is an exceptional tool to help you guys determine candidates. It was developed, I believe, between CPOC and CDSS when ACL 1436 came into being. And you can use and this is a great tool for you to use to determine candidacy. And there are a couple prerequisites for candidacy. The first is the minor has to be under the age of 18. If they're over 18, they would automatically not be a candidate. And then also the minor would have to be the subject of a 602 petition. So if either of these things are not true, then you are not going to be dealing with a candidate. And yeah. And within the evaluation of eminent risk, there's going to be several domains for you to do your evaluation. And one of the questions I get asked the most when looking at the evaluation is, how many boxes do we need to check? And there and at the state level, there is no minimum. Well, one would be the minimum. If you don't have any check, well, you're probably not working with a candidate. Uh, but you would want to have at least one box checked. But depending on the severity of that box that you check, that could potentially be reason enough for that youth to be at serious or imminent risk of going into foster care. The only caveat you need to keep in mind is that for substance abuse, you would have to have one other domain checked off as well. Substance abuse of the for the parent or the minor is not reason enough for documenting candidacy. You would always need at least one other box or domain checked to go along with that. But once you've worked your way through the evaluation of imminent risk, at that point, you would have to make the determination of candidacy. The top box would be if you're not working with a candidate, the child is not or is no longer at imminent risk of removal to foster care. So if not, you're going to stop. They're not a candidate. But if they are a candidate for foster care, you're going to check the bottom box. The child remains at imminent risk of removal to foster care. And then at that point, you can recommend some preliminary services. And then you can also show where your source documents came from, where you drew your information down from for that candidacy determination. But last and not least, though, you would need the probation officer would need to sign it along with your supervisor. So, so that's again a great, the tool that we need to be using to determine candidacy.
Yeah. And the one thing, Mark, I would just share for those that are maybe newer to the candidacy program or Title 4E, if you've come from another unit. And one of the reasons why this particular form was adopted and included in that ACL was when the feds had come out back in 2013, part of their process to learn about how California did Title 4E, specifically how probation did it. They interviewed some deputy probation officers, and we weren't able to articulate what made a youth a candidate. And so this tool was really incorporated to help with that, so that should the feds ever come out again, which they haven't, to look at the candidacy program, but someday they may, we would be better positioned to share what makes any particular case they may pull, what made that youth a candidate based upon their needs or what's identified with their family as well.
Yep. Thanks, Rosie. Yeah. So if you've determined that a youth is a candidate, the next step will be to complete a valid and complete Title 4E case plan, because in California, the preferred method of documenting candidates is going to be a case plan. So today we're just going to take a brief look at the CPOC case plan. And at the top is just going to be some demographic information, the minor's name, the date of birth, the initial, whether this is an initial case plan, a 6-month review, or a changing case plan. We've highlighted this date case plan completed box because the case plan isn't actually completed until you have the signatures that you need. And the last signature is always going to be the supervisor. So the supervisor can actually fill in this date that the case plan is completed when they're signing the case plan. So let's look at a few sections of the case plan that we need to have a valid Title 4E case plan. The first is going to be the narrative, and the narrative is going to, whoops, my bad. The narrative is going to be this box right under where it says, please indicate in the box below the issues and services needed that place the minor at imminent risk of removal. And this is going to be your opportunity to explain in your own words why this youth would go to foster care if the services were to fail. And this box cannot be solely delinquent in nature, right? It has to, remember how I was talking a little bit earlier about how we have to take a holistic view of the family in order to determine candidacy. So this box would have to have the family dynamics. It would have to have the safety issues in the home. It would have to have the challenge. It would have to outline the challenges that the parents are facing, and then also maybe any actions or inactions of the parents that could lead the youth to go into a foster care placement. But really, the more that you're able to focus on those welfare type reasons, the stronger your narrative is going to be. Because when CDSS comes on site to do their candidate reviews, one of the first things they're going to look at is that narrative, and they're going to be looking to see that that narrative has, is not delinquency based. They're going to look and see like I said, all the family dynamics, the safety issues, and inactions of the parents. So the more you can put in the narrative about those things, the better off your narrative is going to be. We also have to have an overall goal, and that overall goal is for the minor to remain in the home. Absent these services, or should preventative services fail, the minor will be removed from the home and placed in a suitable foster group home. Any other overall goal will not be a candidate goal. You could potentially have a placement goal. You could potentially just have the minor to remain in the home as a goal, but without the absent these services statement, you're not going to have a valid Title 40 pre-placement case plan. The youth and family strengths, you're just going to check any that apply. And then the next box, or next part, is the plan placement option. And interestingly enough, this when we come on site to do our candidate reviews, we often see plan placement option issues. You can, this box does have to be filled out. It's not optional. And you can fill in both parts or only one part. So for example, if you don't feel confident recommending family members as a potential placement, then skip down to the group home type or other foster care placements. In here, you can say SDRTP, RFA, foster family home, whatever setting would most benefit the youth if they were to be removed. And then also any services or our focuses of those placements. Now, for family members, there's a couple caveats that we need to keep in mind. The first is we cannot use a family member that is residing at the minor's address. And we also cannot use a biological parent. So even if the parents are separated or divorced and living at separate addresses, we still cannot use a biological parent. And one question that comes up, kind of at least a couple times a year for us, is what if the parental rights have been terminated? And that's a good question. And I actually reached out to CDSS earlier this year. Yeah, earlier this year, and they responded that we cannot use a parent regardless of, even if their parental rights have been terminated, you still can't use the biological parent. So stay away from the biological parents for your plan placement options. And then we also have the objectives and services portion. This is where you're going to be referring services and other objectives to help that family stay together. As a minimum requirement, you would have to provide at least one direct service for the minor and one direct service for the parent.
And when you say provide direct service, it doesn't need to be provided directly by probation,
Right.
but it needs to
No,
be, the
sorry.
goal needs to be directed towards.
Yeah, actually, they're looking for at least one direct service referral for the youth and the parent. So, and we understand the parents aren't on probation, and the referral for the parents is where that stops. It's up to the parent whether or not they follow through with that referral or not. And if they don't follow through with the referral, maybe that's more documentation for future candidacy at the 6-month mark. So, so after you've done the objectives and services, then you're going to basically say what you're going to do as the probation officer. And lastly, we're going to get our signatures. And the order of the signatures does matter. The minor and the parent should, in theory, sign first. The third signature would be the probation officer, and the final signature would be the probation supervisor. And the date that the probation supervisor signs is the effective date of the case plan. And keep in mind that case plans are only valid for 6 months. So you're going to want to go through this review process of candidacy before that 6-month mark hits so that you don't potentially lose any downtime on your candidate claiming. And then you can also document any predetermination time that you spend working on the case. So if you are doing case management, or if you're working on the case plan or providing any other sort of case management, you can document that in those dates below. because federal and state guidelines basically say that any time that you spend doing case management activities in the month that the case plan becomes valid is going to you can claim that. So you definitely want to be tracking that. If you're using the RMS system, we're already tracking that because the RMS system is case specific. So we can easily go back and identify any candidates that became candidates in that month. So, all right. Now that we know how we can claim, we have to put together the claims. And I'm not really a fiscal guy. I know a little bit to be dangerous. And but I just wanted to tell you our process when we put together an administrative claim. So basically our fiscal contacts are going to reach out to your fiscal contacts and request data for the quarter. And then our accountants are going to go through that data with a fine-tooth comb and end up with an allowable cost pool. But I will say that probably 80 to 90% of your allowable cost pool, and in many instances, 100% of your cost pool is just going to be your officers and supervisors that are part of the time study. So that's going to be a huge part of your cost pool. And then once we have your cost pool put together, we're going to apply the time study percentages. And then once we apply the time study percentages, we are going to plot to apply an indirect cost rate and then a federal eligibility rate. And your federal eligibility rate, we end up getting from your child welfare department. It's just going to be a ratio of your Title IV eligible youth and placement that basically you're drawing down assistance or maintenance for, divided by all of your youth and placement. And that's typically going to be a countywide number. So your probation and your child welfare numbers are going to be typically combined for that ratio. And then lastly, we're going to apply the federal and state participating sharing rate. So usually that's just going to be 50% federal, 50% county, but there are some codes where we get to draw down some state funds like child and family teams, resource family approval, things like that. And then last but not least, once your claim is ready, you're going to submit that to your child welfare department, who includes your cost and their claims. And then your child welfare department will send their claim to CDSS, and then CDSS combines all the county's claims into one massive claim and sends that on to the feds for reimbursement. So that is, again, a super high level view of Title IV-E. I wanted to stop real quick and see if there's any questions so far. And if not, then I want to share some of our most frequently asked questions that we get asked at JBI.
Yeah, so if anyone has any questions, do feel free to drop them in the chat or raise your hand, and all questions are welcome, really intended to be informational. So to the extent that you would like clarification or have a follow-up question on anything, happy to, we can either take those now or certainly we'll have time throughout the remainder of our time on the workshop. But if anyone has anything that they've been holding and waiting for the right time, feel free to ask that now. But there isn't anything in the chat at this moment, Mark.
Okay, great. Then I will keep trucking along. All right, let's take a look at some of the questions that we get asked frequently. All right, admittedly, this is going to be kind of the salesy part of the presentation, because our main product is a random moment time study. But we do get often asked, what is a random moment time study? How does it work? And what are its advantages? So let's take a quick look at that. So the random moment time study, it's really it's a valuable methodology that we use to determine portion of time that's spent on reimbursable activities. So basically what we do is we leverage statistically valid random moment sampling, and that provides us with accurate data with reduced administrative burden. And I'll kind of go into more detail about what that means. But this is, again, just a kind of a high level introduction to RMTS to help you understand its workings and some benefits. So the random moment time study is going to operate through a scientifically rigorous process. It begins with the selection of participants at random times to ensure unpredictability and unbiased sampling. So that way, no participant in the time study can anticipate when they're going to receive a moment. And these participants are going to provide very quick feedback to us. In California, a random moment has to be answered within 72 hours of receiving it, which doesn't include weekends or holidays. But but by but basically by having to respond rather quickly, it's going to eliminate recall bias. The problem that we run into in our continuous time studies and our mid-month time studies that we run is that oftentimes we see that officers aren't filling those out on a daily basis. Sometimes they're waiting till the end of the week. Sometimes they're waiting to the end of the month. Sometimes they're waiting to the end of a quarter. And when you do that, you're going it's going to be difficult to remember what you were doing every day to get caught up. In fact, uh, I just tried doing that because I'm not very good at answering my time study. But but anyway, but yeah. So after 72 hours elapses, that moment would be considered missed. It doesn't count for or against reimbursability, but it would count against validity. So once a time study is completed, the collected data is analyzed to produce a comprehensive overview of how the department spent its time as a whole. And it also and it also drills down to the specific activities, which is crucial for accurate federal reimbursement. Now, one of the biggest things about a random moment time study is understanding confidence levels and margin of errors. So, in a random moment time study, statistical metrics like confidence level and margin of error are crucial for assessing reliability. In California, we have to have a 95% confidence level with a 5% margin of error. So what that means is that a 95% confidence level is going to assure that the reported data will be accurate in 95 out of 100 repetitions of the study. And meanwhile, a 5% margin of error defines the precision range, showing how close the results are likely to be true to the true values. So basically, this is just a balance of confidence and precision, and it makes RMTS data highly credible for decision making and federal reimbursements. And California is actually the only state that JBI works in that allows paper time studies like the continuous time study and the mid-month time study. Many states are going towards these random moment time studies now just to have these confidence levels and reduce margin of errors. So what are some benefits of an RMS over a paper time study or a personal activity report? Well, the most significant is going to be efficiency. So RMTS is going to eliminate the need for continuous and detailed record keeping, which is time consuming. And moreover, the RMTS is going to use real-time data to ensure higher accuracy and reducing reliance on memory. And this methodology also proves cost-effective by optimizing resources and minimizing errors. And these benefits make RMTS a preferred approach for organizations seeking reliable data for federal reimbursement. And another advantage of the RMTS is that it is uh, oh my goodness, I just lost the word. It's specific, so we can track who we're claiming on per each code. So, for example, if uh, in at JBI, if you claim a reimbursable candidate code, it's case specific. That's what I was looking for. We can actually track the cases that are being coded. So our candidate compliance program, for example, if any officer during the quarter codes a candidate moment, then we can track that to a specific case, and we can go and we go on site to our clients, and any federal reimbursement for a candidate actually goes through a vetting process to make sure that all of the state and federal guidelines are being followed, that the case plan is good for claiming. And if it's not, then we offer some tips on how to bring it into compliance. So I will say that there is a drawback to the random moment time study, and that is the moment, what I'm going to call the moment burden. In California, we are required to send out 2,500 moments a quarter. So counties that have very few time study participants, and I think the most that we are the least number of participants that we have in any of our random moment time studies is 5. Um, so really, if you have, 5, 6 lower, a lower number of time study participants, it's going to be difficult to answer 2,500 moments in a quarter. So that's why we do have other services for continuous time studies and mid-month time studies as well. So maybe
And
there's some questions.
yeah, no, just someone can't see the PowerPoint anymore, but it's
Oh,
showing on my end. So I'm wondering, and I haven't, no one else has posted that they're having that issue, so I don't know. I'm suggesting, Twyla, if you could maybe log off and come back on, because it might be something perhaps with your internet connection, perhaps. I'm not quite sure. But let's see if that works. And then, Mark, I did have a question. I was just curious for the other states that are switching over, and just to allay anyone's fears, we have not heard, or that has not been something that California has talked about. So at this time, if you, whether you do random moment or you do continuous, those both, all three methods that Mark mentioned are permissible. But I was just curious, in the other states that are moving to the random moment, are those states helping cover the costs for doing that? Because I know right now that's something that's worked out between JBI and those counties, because there's obviously other ways to complete the random moment. And if you don't know, that's fine too. I was just curious.
yeah, actually in those states, ever since we started working in those states, it's just always been random moment time studies.
Oh, okay.
Yeah. So, yeah, I don't know if yeah, I just don't know if they help with the administration costs of implementing those.
But again, just to allay everyone's concerns, there's
Yeah, yeah,
no no
don't fear.
movement
You could,
afoot in California to require anyone to do random moments. So, but
yes,
thank you for highlighting.
absolutely. Absolutely, absolutely. And we have had a few counties that we work with that started off in our mid-month or our continuous time studies and moved to a random moment time study. And those counties definitely increased their reimbursable percentages by moving to a random moment time study. Just because I think there's just something about asking an officer about, what are you doing right now? You know, and it's just being g- just getting being sorry being able to get rid of that recall bias,
Yeah,
I think helps a lot.
and are you finding in some of those instances they may be doing something that's claimable and they hadn't realized it, and so you were able
Yeah.
to capture that opportunity?
Yep. Absolutely. Absolutely. So if you're not in an RMTS and would like to see a demo or have more questions, feel free to reach out to me and we can arrange for that. All right. Again, before we get into this, super high level. I'm not going to get into any weeds here. I'm just going to kind of show you the high level differences between Title 4E and the Family First Prevention Services Act.
That's good because
So,
we would probably need many more hours to our.
oh, yeah, we'd probably need like a 2-day workshop or a 3-day workshop, week long. No. But again, this is just super high level, y'all. So under Title 4E, kind of the main goal is to make sure kids don't stay in placement. We really want to reunite families. We want to find adoptive homes. And there's a limited amount of prevention that is involved with Title 4E. Under the Family First Prevention Services Act, the main difference here is we're trying to make sure that youth don't go to placement at all. And if placement cannot be avoided, then it greatly discourages congregate care placements, as you probably know, in favor of foster family homes, resource families, etc. So under traditional Title 4E claiming, like we mentioned kind of before, our populations are going to be youth in foster care and extended foster care and reasonable candidates. And we cannot direct bill services under traditional Title 4E. And an eligibility rate that's also, you might call it a discount rate, a penetration rate, whatever you call it. Eligibility rates are applied to all of our PIN codes except the CSAC PIN codes right now. So under Family First Prevention Services Act, again, we're going to be discouraging those congregate care placements. And instead of that, we're going to be focusing on prevention through the use of promising, supported, and well-supported evidence-based practices that are delivered in a trauma-informed manner. And our populations for Family First Prevention Services Act are going to continue to be youth in foster care and non-minor dependents. But interestingly enough, parts 1 and 4 of FFPSA are going to apply to youth in foster care. And part 1, sorry, is prevention services. Part 4 is the placement side of FFPSA. So you might be asking yourself, how can a youth in foster care be eligible for prevention services? Well, that's because there's part of FFPSA that says that pregnant and parenting youth in foster care can be prevention services candidates. So that's how you would have both part 1 and 4 for youth in foster care. Under FFPSA, you're also going to be able to continue to claim your traditional reasonable candidates. These are, again, going to be youth at serious risk of removal from the home. You're providing services to keep them in the home, and if those services were to fail, they would go into foster care. The difference between a traditional reasonable candidate and a prevention services candidate is going to be that your prevention services candidates are going to be receiving services that are outlined in the state's 5-year prevention services plan. So, so when FFPSA actually becomes claimable in California, which is probably going to be when CWS Cares is up and running in, I believe it's October of next year, or no, October of 26. So, we don't really have to worry about that until then. But it's interesting because traditional candidates and prevention services candidates are kind of defined in 2 separate parts of the Social Security Act and the Child Welfare Policy Manual. Traditional reasonable candidates are defined in 472I of the Social Security Act, and they are outlined also in 8.1D of the Child Welfare Policy Manual. And prevention services candidates are outlined in 475.13 of the Social Security Act and 8.6 of the Child Welfare Policy Manual. So another really big difference between Title 4E and FFPSA is direct bill services. So if you are utilizing services that are evidence-based practices that are outlined in the state's 5-year prevention services plan, then you could draw down, you can claim that for 50% of your costs, but there's obviously going to be a caveat with that as well. And that is if those services aren't covered by another payer. So Title 4E is always going to be, or FFPSA is going to be the payer of last resort. So if Medi-Cal or Medicaid or Medicare or private insurance is paying for the EBPs, then Title 4E would not. And then another really big difference is eligibility rates. So our eligibility rates are not going to be applied to prevention services candidates, and they wouldn't be applied to your prevention services that you're providing that are in the state's plan. So we talked a little bit earlier about how you have your costs, then you apply your time study, then you apply your federal eligibility rate. Well, you skip that step. You skip the federal eligibility rate step for your prevention services in Part 1 of FFPSA. So you're going to basically be drawing down a little bit more money because we don't have to apply that federal eligibility rate. So it's just going to be a flat 50% FFP, or in 2026 FMAP, or 2027 FMAP, I can't remember which, but that's 50% too in California, so it doesn't matter. All right. So how will FFPSA Part 1 impact my claim when CWS Cares is live? And the short answer is I don't know. But I can also, but I'm going to take a few guesses here. I'm going to take some liberty and make a couple guesses. And the first is I think we're going to probably see some immediate shifts. The first shift that I think we're going to see is we're going to see a shift from traditional candidacy, that would be the 0128 PIN code for you fiscal folks, to whatever the new PIN code is going to be for FFPSA candidacy. And that would apply to your prevention services candidates. I think a large, a good portion of our prevention services candidates are just going to shift from our current candidate code or candidate PIN code. And ultimately, you're going to probably see fewer dollars being claimed to the 0128 candidate PIN code, but you're going to see an actual increase because we're not going to have to apply that federal eligibility rate to your prevention services candidates. Now, the other shift I think we're going to see is potential, and this is especially if your county is going to be utilizing a community pathway, is potentially a shift from probation only to FFPSA candidacy. So the 5-year prevention services plan opens up FFPSA candidacy to 10 categories of youth that will not necessarily need to be subject to a 602 petition if they're receiving one of the 10 EBPs that's outlined in the state plan, and they've been found to be at serious imminent risk of a foster care placement if the EBPs fail. So, so right now you're not drawing down any money for any youth that are not subject to a 602 petition. But if they fall in any of those 10 categories in the state's plan, and I actually went ahead and got that somewhere. I pulled it up. Is that it? No, that's not it. Oh, never mind. We're gonna get back to the PowerPoint. I pulled up a bunch of stuff.
Mark, maybe while you're thinking your next thought, I was just going to say, and for those that do traditional candidacy now and have not opted into part one, this may sound like a foreign language, and so part one is an optional program as well, so you can continue down your traditional road. And not have to opt into part one if you don't feel it, is cost effective for your department. So
Yeah, that's a great point, Rosie. Yeah, if you don't opt into part one, it's just really going to be status quo, for your claiming. It probably won't go up, probably won't go down. It's probably just gonna kind of stay where
yeah.
it is.
And then if anyone becomes interested after this discussion, there's nothing that precludes a department from opting into the future onto part
Mhm.
one. So if 3 years from now you decide you do want to, then you can move forward and certainly work with the state, JBI, certainly us, to help with that process. So
Yeah, absolutely. So, uh, is that? Can you see that now? Do I have that pulled up correctly?
yes.
Okay, great. So these are potential candidates for prevention services funded by Title IV-E in the state's plan. The first two are going to be traditional pathways. So that's going to be children in voluntary or court order family maintenance service, and our probation minors subject to a petition under Section 602, and for whom they've been determined to be at imminent risk of foster care. So the next ones are going to be, the 10 categories that that state is kind of opening up candidacy to through what you might call a community pathway, but these aren't traditional pathways to Title 40 candidacy. So it's children whose guardianship or adoption arrangement is at risk of disruption, children with a substantiated or inconclusive disposition of a child abuse or neglect allegation without a case being open, children who have siblings in foster care, homeless or runaway youth, our LGBTQ children, substance exposed newborns, commercially sexually exploited youth, children exposed to domestic violence, children whose caretakers experience a substance use disorder, and children or youth experiencing other risk factors that, when combined with family instability or safety threats, would be assessed to be at imminent risk of foster care. So those are the 10 categories that the state is opening up to candidacy through a less traditional method.
And the one other thing that I would highlight, which I know is one of the benefits of part one, that is different than traditional candidacy, is that what has been a hindrance for some is that many of the, well, I shouldn't say many, but some youth that probation works with who live in the family home, live with a relative, maybe a
Yes.
grandma who never became legal guardian, but because they're not the legal guardian, we can't claim them under traditional candidacy. Whereas with part one, they do make it allowable. So in those instances, that youth, you could, if they met all the, imminent risk, they could be a candidate under part one if your county department was opting in.
Yeah, yeah, that's a great point. So that's another potential shift right there as well from what we what we're not currently claiming. We're claiming $0 for right now. You could potentially be claiming those as prevention services candidates. So I also would anticipate seeing some longer term claiming shifts if FFPSA Part 1 is successful. So, I think if it's successful, then we're going to end up seeing fewer placements with lower placement costs, which is going to reduce our foster care and extended foster care case management claiming over the long run, as well as our assistance claiming if those placements go down. But, you know, uh, you could potentially reinvest that money that you're saving by fewer placements to provide a more robust set of prevention services. So just a few things that I would anticipate seeing. Um, All right. We get this question all the time. Do youth need to be 602 wards to claim candidacy? And I am going to refer y'all to a really great resource. Some of you don't know it even exists, but it does. And this was a document that was developed jointly between CPOC and CDSS. And it has, I think, 11 or 12 FAQs on it. And this is a great resource, y'all. You need to check it out because a lot of your questions are probably going to be on traditional candidacy or going to be answered in this FAQ. So, but let's take a look at this. Are youth categories listed in Welfare and Institutions Code 654.2, 725A, and 790 claimable as reasonable candidates? And the answer is yes. These youth may qualify. They don't automatically qualify, obviously, as reasonable candidate as long as a 602 petition has been filed in the court and all Title 40 reasonable candidate requirements have been met as identified in ACL 1436. CDSS recognizes that there is a very small subset of youth in these categories that may qualify for Title 40 pre-placement. It is important to note that while a youth is not required to be a 602 ward, if your probation department designates a 654.2, 725A, or 790 youth as a reasonable candidate, it is highly recommended that your department have strong documentation to support the youth candidacy designation, as well as have examples from your jurisdiction where your probation department has placed youth from these levels of probation directly into an out-of-home placement. And that last sentence is where a lot of counties are probably going to may shy away from doing that, just because you don't really place kids from those designations unless you bring them onto a 602 petition to, for the purpose of placing them. But typically, you're not directly going to be placing kids that are 654.2, 725As, or 790s. But really, it comes down to how your county analyzes this and puts it into practice.
Right.
But again, I put a link in my PowerPoint. We're going to send out a PDF of the PowerPoint to everybody. I don't know if the link would work to get in the PowerPoint or not, or
Oh, that's a good
in the
idea. No, we can
PDF.
certainly include a link to that that document. I spent hours of my life working on that document along with the probation work group in DSS. And sometimes I forget it's on the website. Mark, we do have a question
Oh,
in
yeah.
the chat. And so the question is, can EFC claims include parents? The non-minor dependent parents home.
Oh, like a TILP or a SILP? Like a TILP or a SILP? Like if a youth is in a
Saying
supervised
yes.
independent? Yeah, absolutely.
Okay. And you also got a thank you. So no other questions in the chat this time.
Great. Yep. Yeah, actually, that's one of the that's a great question because that is one of the most common coding errors that we see oftentimes on the non-minor dependents, because oftentimes we'll ask where's the child residing, and if they're residing in the home, then yeah. So we've actually switched that up on our new time study to identify what type of youth are you working with now instead of where is the child located. So if you're working with a non-minor dependent in a TILP or a SILP, in our time study, you want to say that you're working on extended foster care to get to the correct codes for that. All right. And sometimes we get this question, is there a difference between imminent and serious risk of entering foster care? And this is answered in the Child Welfare Policy Manual in section 8.1D, question 10 of the Social Security. So the Social Security Act describes a candidate for foster care as a child at imminent risk of removal. Does the Title 40 agency have to use the term imminent risk in the case plan to document a child's candidacy, or is it permissible for the Title 40 agency to document that the child is at serious risk of removal from the home to satisfy this requirement? And the answer from the feds is we consider the term serious risk of removal to be synonymous with imminent risk of removal. And I like this a lot just because sometimes imminent has the connotation of it's going to happen immediately. Like it's going to happen next week. It's going to happen within 2 weeks, and whereas with serious, it doesn't have that connotation of it's going to happen immediately. With serious, it's more of a connotation of the definition of if the services were to fail or if the services were not being provided, then the plan for the youth would be to go to foster care. So I mean, both words are federally fine. And sometimes I just find it's easier to relate to serious than it is to relate to imminent. But again, both are fine for federal context. So, imminent may imply the following: imminent or impending danger or threat that could result in the removal of a child from a home. Safety or well-being is at immediate risk and urgent action is required for protection. Risk might be due to immediate danger or harm, such as severe abuse, neglect, or a hazardous environment. Meanwhile, serious could imply the following: the situation where a child is facing circumstances or condition that place them at a significant and concerning level of vulnerability or harm. Factors or issues present that could potentially lead to the need for foster care or indicate that foster care may be the best option for the child's safety and well-being. And some factors could include parental neglect or abuse, unstable living conditions, or a lack of appropriate care or supervision. So, oh, sorry. Did I have that pop up in the middle of the screen?
I didn't see anything.
Oh, okay, good, good. All right. And that is that's kind of a wrap. That's pretty much all I had for y'all today. I appreciate the time. I appreciate I appreciate all the relationships that we have with our JBI counties and look forward to making more relationships.
Great. Thank you so much, Mark. And again, we do have a few minutes left. If there were any other questions and folks wanted to ask a follow-up related to whether it's the item imminent versus serious that we just discussed, or if there's something else that was said earlier that you would like to go back to, we do have a few minutes if anyone else would like to pose a question either in the chat, or you can unmute yourself and raise your hand and we can certainly call on you.
And that's my phone number and my email address. If you have any questions or want to get in contact with me for any questions, happy to help any way I can.
Yeah. And Mark, I just want to, as we do wrap, and I just want to thank you. You've been a great partner and very knowledgeable on all things 4E. So appreciate it, and helpful because you can bring perspective from other states, knowing that JBI is in other states and what's happening across the country. But also know that folks, a lot of times, at least back in 2013, probation was one of the few departments, from my knowledge, that was doing candidacy back at that time. So I know a lot of folks were looking at us, but I will just stop one last time. Not seeing any questions in the chat. So if not, then I will wish everyone a wonderful weekend. We will send out the PowerPoint along with the link to the FAQ page that Mark mentioned. And again, that will have his contact info if you have any questions or want to reach out to him directly to learn more about JBI services. So with that, thank you, Mark, and thank you, everyone, and take good care.